Joanna Cherry.
Thank you, Madam Deputy Speaker. Can I commend the Honourable Member for North Shropshire on her excellent maiden speech, and also commend her on her excellent and pretty amazing by-election victory. I'm rising to speak to Amendments 1 to 3 and 5 and 37, which stand in my name and those of other honourable members. And my sponsorship of these amendments arises from the legislative scrutiny of this bill by the Joint Committee on Human Rights. And the mother of the House, our chair, who would normally speak to these amendments, cannot be here today because of her bereavement. And I want to extend my deepest sympathies to her and her family, and to pay tribute to her late husband, the Honourable Member for Birmingham Erdington, who was a widely respected and loved man. I would remind honourable members that the Joint Committee is a cross-party committee with half its members from the Commons and half its members from the other place, and we undertake legislative scrutiny of all bills for their human rights implications. And we've taken evidence from a number of people on this bill and been advised by our own legal experts. And we published a report on 7th December last year, which was a unanimous report, so it had cross-party support from across both houses. And we concluded in relation to Clause 1, Madam Deputy Speaker, that if it was enacted, it wouldn't guarantee that an individual would receive an effective remedy for a violation of their human rights. And we recommended that the government remove the requirement in that clause, as it amounts to an unnecessary intrusion into judicial remedial discretion. And as I say, that's an informed view reached on a cross-party basis after taking evidence, and that would be the effect of Amendments 1 to 3 if they were to be passed. We also recommended that the legislation should be amended as a fallback position. If Amendments 1 to 3 aren't passed, as a fallback position, the legislation should be amended so that the courts would have to have regard to the convention rights of any person who would be affected by such a decision, and the duty to provide an effective remedy for a human rights violation under Article 13, so that when deciding to make a quashing order with suspended or prospective-only effects, convention rights would require to be taken into account. And that would be the effect of Amendment 37, which I reiterate we see as a fallback if Amendments 1 to 3 are not passed. Turning to Clause 2 of the bill, we hold the same view that was articulated by my honourable friend about CART judicial reviews. And we reached the conclusion that judicial supervision of the upper tribunal protects against legal error. Only a small proportion of CART judicial review applications are successful, but in some of those, individuals could be prevented from being wrongly removed from the United Kingdom to face the most heinous human rights violations in other countries. And we said that rather than taking this hammer to crack a nut, the government should introduce procedural reforms, such as changes to the time limits for bringing CART reviews, assessing their impact before pursuing this nuclear option of ousting judicial review in CART cases. And we also said that every effort must be made to ensure that the initial decision makers and the first-tier tribunal make the best possible decisions when cases are before them, and that would limit the need for asylum seekers to rely upon a third opportunity to have their application for permission to appeal considered. And this would be the effect of Amendment 5. And just generally on ouster clauses, which other honourable members have spoken about this afternoon, the Joint Committee on Human Rights said in our report that we are concerned by the government's indication that the ouster clause designed to reverse CART here will be replicated in other legislation. And clearly we are concerned about the possibility of undermining the rule of law, which is essential for the protection and enforcement of human rights. Now, just before I sit down, I also want to give my personal support to the amendments tabled on behalf of the Scottish National Party, and to reiterate what I said at second reading in relation to this bill, which is that it's not constitutionally appropriate for the exclusion or review of upper tribunal permission to appeal decisions to extend to Scotland. The Minister who's in his place has conceded to me in a letter dated 10th November that Clause 2 will alter the jurisdiction of the Court of Session. It's not for this place to alter the jurisdiction of the Court of Session. That's not just a contravention of the devolved settlement, it's a contravention of Article 19 of the Act of Union. Now, I know the Minister will say, oh no, it's not a contravention of Article 19 because it's a regulation for the better administration of justice. Well, I'm sorry, in Scotland we don't see regulations that circumscribe the availability of justice to individual members of the public as something that's for the better administration of justice. The Law Society of Scotland have been clear that a legislative consent motion is required, none has been sought and none would be granted for an interference with the jurisdiction of the Court of Session. And finally, as I addressed in my second reading speech, there's no evidence base that there's any mischief in Scotland in relation to CART judicial review. We actually call it ABAR judicial review because of our case. The evidence base which the government presented was completely confined to cases in England. So if Clause 2 goes ahead, it will just be another example of this government overriding the devolved settlement, undermining the union. So please, Minister, leave Scotland's legal system to Scotland's Parliament where it belongs.